This is the brief on the legal penalties for falsifying documents. You know, legally, forging a document isn't a one-size-fits-all crime. The penalties, which include serious jail time and fines over $1 million pesos, change drastically based on exactly who you are and what you're faking. First, let's talk about the who. The law reserves its harshest penalties, like prisión mayor, meaning major prison time, for public officers, notaries, or ecclesiastic ministers taking advantage of their positions to alter facts. Think about it like a referee cheating versus a fan. The ref holds the public trust, right? So their betrayal is punished way more severely than a regular person. Second, the type of document matters just as much. Falsifying legislative bills carries the highest fine, up to a whopping 1.2 million pesos. Also, faking a public document is a crime regardless of your intent. So, what does this mean if you just fake a private note as a harmless joke? Well, without the actual intent to cause damage, faking a private document doesn't trigger that same criminal liability. Finally, let's shift from paper records to the wire. The law specifically targets telecom and corporate employees who falsify wireless, telegraph, cable, or telephone messages. See, it doesn't just protect the paper we sign, it aggressively protects the integrity of the very communication systems we literally rely on every single day. Ultimately, the severity of a lie in our legal system is measured entirely by the power of the liar and the public importance of the record itself.
Welcome to The Anatomy of Deceit, a forensic analysis of falsification under Articles 170 to 173 of the Revised Penal Code. This video offers an analytical summary and jurisprudential framework on this crucial subject. Falsification laws protect the infrastructural pillars of public faith, organized into 4 tiers. Tier 1 covers lawmakers and legislative documents. Tier 2 protects documents handled by guardians of trust like public officers. Tier 3 addresses citizens and commercial documents. And Tier 4 pertains to communicators via cable and wireless technologies. Domain I covers corrupting the legislative intent under Article 170. This involves unauthorized alteration of a genuine bill or resolution that fundamentally changes its meaning. The penalty can include prison correctional and a fine up to P1,200,000. Domain 2, the falsification funnel under Article 171, applies specifically to public officers. The elements require the offender to have official status, access, abusive position, and the commission of one of the 8 statutory acts of falsification. The 8 acts of deceit can be categorized into fabrication, alteration, and misattribution. Fabrication involves creating non-existent things, alteration corrupts what is true, and misattribution means lying about facts or actions. The diagnostic matrix differentiates pure simulation from alteration. Pure simulation, which includes paragraphs 1, 2, 3, 4, and 5, does not require a genuine original document. Alteration, including paragraphs 6, 7, and 8, strictly requires a genuine document that is falsified by physical alteration, as defined by the Pacana Doctrine. The unruthful narrative litmus test, under Article 171, paragraph 4, has 3 locks. The statement must be a narration of facts, the offender must have a legal obligation to disclose the truth, and the facts narrated must be absolutely false. Forensic axioms provide key jurisprudential guidance. The Rampus rule relates to the intent to imitate. The Emis exception concerns private intervention. The Siquian doctrine addresses wrongful intent for public documents. And the Manansala presumption involves the possession of a falsified document. Domain 3, under Article 172, defines the objects of deceit. These include public documents, official documents, commercial documents, and private documents. Each type has specific examples illustrating their nature. The nexus of liability depends on the actor and the document type. For public or commercial documents, damage is not required. However, for private documents falsified by a private individual, damage or intent to damage a third person is strictly required. The chain of falsified use addresses the use of a falsified document. If introduced as evidence in judicial proceedings, damage is not necessary. In other transactions, damage or the intent to damage another is strictly required, and the user must know the document was falsified by another. Collateral offenses include falsification as a necessary means to commit a complex crime, requiring the document to be public, official, or commercial. It also covers falsification through reckless imprudence, which is valid for public and commercial documents. Domain IV, intercepting the wires under Article 173, involves two nodes, the inside operators and the private citizen. Inside operators face prison sentences, while the private citizen altering a telegram is punished under a specific special law with a minimal fine. The gravity of the breach scales the elements of falsification based on the victim. For private documents, the victim is the individual, requiring actual damage. For public, official, or commercial documents, the victim is society, and the violation of public trust is the damage. In the falsification of a public document, the principal thing punished is the violation of public faith and the destruction of truth as therein solemnly proclaimed.
Have you ever filled out a form and thought, maybe I could just fudge this one little detail? I think we've all been tempted. But where's the line? When does a tiny white lie on a piece of paper suddenly become a really serious crime? Well, today we're diving deep into the law on falsified documents to find out just that.
So what is that line in the sand? When does an untruth go from being just, something you say, to something that could actually land you in some serious trouble? Legally speaking, the answer has everything to do with the document.
Okay, let's get our key definition down. Falsification isn't just any old lie. Nope. It's the specific crime of corrupting the truth within a document. It's about making a piece of paper, or, a digital file these days, tell a lie and pass itself off as the truth. And this is a huge deal, because our entire society pretty much runs on the assumption that we can trust certain documents.
Now, the law draws a really big distinction based on who is doing the falsifying. So first up, let's talk about the people we entrust with our most important records, public officers.
So you can think of this crime as having two main paths, and it all depends on who's behind it. For a public officer, the absolute is that they are abusing their position of power. But for a private individual, the law is usually looking for something totally different, the intent to cause harm. Let's start with the public officer side of things. Under Article 171 of the Revised Penal Code, the law is crystal clear. It's aimed squarely at public officials, employees, or notaries. And the two crucial ingredients are, 1, their official role, and 2, the fact that they took advantage of that role to do it. See, they have a duty to protect the truth of a document, but instead, they use their power to corrupt it.
So what does this actually look like? Well, the law gives a few examples. Think about it. Faking a signature on an official government form, or maybe adding someone's name to the minutes of a meeting they weren't even at, or even just deliberately writing a false story of what happened in an official report. All of those, classic examples.
But why is this treated so seriously? Well, for public documents, the crime isn't really about one person losing money. The crime is against what the law calls public faith. It's basically an attack on the trust that all of us place in our government and its records, and that's exactly why prosecutors often don't even need to prove that someone was financially harmed. The violation of trust is the crime.
And the penalties? Oh yeah, they definitely reflect that severity. We're talking about a pretty long prison sentence, what the law calls prison mayor, plus a fine that can soar all the way up to 1 million pesos. The message is loud and clear. If you're a guardian of public documents, breaking that trust is going to cost you a lot.
Okay, so we've seen the super high standard for public officers. But what about, the rest of us? Let's take a look at how the rules change when we're talking about private individuals.
Right, this is where the law kind of shifts gears. If you're just a regular private citizen, the rules are different, and it often boils down to what you were trying to do and what actually happened because of it.
The big differences are all laid out in Article 172. So now we're talking about any private individual. And the core element? It completely flips. It's not about abusing an official position anymore. Now the law is looking for damage or intent to cause damage. The prison time is usually shorter, prisión correccional, but that fine can still be just as high.
So this is the bottom line. If you, as a private person, falsify a private document, like say a simple receipt or a personal IOU, it only becomes a crime if you actually harm someone with it or if you clearly meant to. Just faking the document isn't enough by itself. It has to be connected to hurting someone else.
But, and this is a really important twist, if a private person fakes a public or official document like a driver's license or a passport, that whole requirement for damage, it just goes away. Just like with the public officer, the law sees that as a violation of public faith. The act itself becomes the crime, whether anyone got hurt right away or not.
All right, so beyond those two big categories, the law also singles out a few very specific situations, which really shows you just how broad this idea of falsification is.
For instance, Article 170 creates a special crime just for messing with legislative documents. If you go in and change the wording of a bill or a city ordinance when you have no authority to do so, that's a direct attack on the lawmaking process itself, and it's punished as its own separate thing.
And the law even tries to keep up with technology, or, the technology of its time. Article 173 makes it illegal for someone working at a telegraph or phone company to just invent a fake message or change a real one. It proves the principle applies to any system our society relies on for truthful communication.
So after running through all these different rules and articles, what's the big picture here? Why does the law care so much about what's written on a piece of paper?
Is because these laws aren't just about catching individual liars. The idea behind them goes so much deeper than that. What these laws are really doing is protecting the very foundation of trust that our whole world is built on. I mean, think about it. Contracts, birth certificates, property titles, court records, our entire economy, our government, and even our personal identities depend on the integrity of these documents. Without that trust, things would start to fall apart really, really fast.
And there's this incredible phrase from legal scholars that just sums it all up perfectly. These laws exist to protect the truth as therein solemnly proclaimed. A document is a solemn declaration of a fact, and falsification is the act of shattering that promise.
Which leaves us with one last thing to think about. We've talked about paper and telegraphs and phone messages, but today our most important documents are digital. They're spreadsheets, PDFs, even blockchain records. So how will these old principles, designed to protect a solemnly proclaimed truth, hold up in a world of deepfakes and sophisticated digital forgery? Well, that's the challenge for the next generation of law.
Usually when we think about the physical objects that exert absolute control over our lives, we picture things with obvious weight and presence.
Right. Things that take up actual space.
Yeah, exactly. A car, a house, maybe a server rack humming in some massive data center.
Sure.
But there's this strange expectation of permanence and, truth that we assign to something incredibly fragile. I mean, just a single piece of paper.
It's wild when you really stop and think about it.
It really is. You sign a receipt, or you fill out a tax form, or maybe you just click a box on a digital document. And suddenly that invisible, weightless signature becomes the absolute bedrock of your reality.
It binds it completely.
It does. So today we are doing a deep dive into the penal code to figure out how fixing a typo on an official contract can be perfectly legal, but filling out a routine time card wrong could result in a 1 million peso fine and years behind bars.
Yeah, the transition from a mere piece of paper into a binding legal artifact is honestly one of the most foundational concepts in modern society.
Because we have to have a record.
Exactly. We need our societal agreements to be visible, to be perfectly categorized, because if we don't trust the paper, the entire system of commerce and governance just completely falls apart.
Right. It all collapses.
And the law acknowledges this fragility, which is why the jurisprudence surrounding the falsification of documents, specifically Articles 170 through 173 of the Penal Code that we are examining today, is incredibly intricate.
It's like a labyrinth.
It really is. We are looking at a legal landscape that attempts to codify the very concept of truth.
And for you listening right now, you might think, well, I'm not a master forger creating fake passports in a basement, so why should I care?
Right. People think it doesn't apply to them.
Exactly. But every single time you sign a delivery receipt at your front door, or every time you fill out a medical form at the doctor's office, or even just send a professional message at work, you are interacting with the invisible architecture of these exact laws.
We're participating in the system.
Yes. The courts don't just look at the lie itself. They look at the container of the lie. Certain pieces of paper carry an immense, almost sacred weight.
That hierarchy of truth is really the central theme here. The law places the absolute heaviest burden on the people society officially appoints to guard that trust.
The insiders.
Yes, the insider threat. Article 171 deals specifically with public officers, employees, and notaries, and the penalties here are incredibly severe.
How severe are we talking?
Well, if an individual in one of these roles falsifies a document, they face what the law calls prison mayor.
Okay, what does that translate to in actual time?
In the context of this legal framework, that translates to a serious prison term ranging from 6 years and 1 day up to 12 years.
Wow.
Alongside a fine that can reach up to 1 million pesos.
12 years and 1,000,000 pesos just for forging a document. That is a massive hammer to swing.
It is meant to be a deterrent, absolutely.
But there's a specific hinge in the language of Article 171, right? I mean, the phrase is taking advantage of his official position.
Yes, that is the crucial qualifier.
It's because it's not enough to just draw a government paycheck to get hit with that 12-year sentence.
Right, no, not at all. To trigger that specific severe penalty, the offender must have a duty to make or prepare or otherwise intervene in the preparation of the document. Or they must have official custody of the document they are falsifying.
Okay, so they have to actually be using their specific power.
Exactly. If a public officer falsifies a document that has absolutely nothing to do with their official duties, the courts do not evaluate them under Article 171.
Oh, really?
Yeah, they are treated under a entirely different section, Article 172, which applies to private individuals and carries significantly lower penalties.
Okay, let's unpack this. Let me test the boundaries of that logic. Is this essentially like a bank teller stealing from the vault versus a bank teller stealing from a grocery store?
That is actually a perfect analogy.
So if the teller takes money from their own cash drawer at work, they are abusing the very specific access given to them by their employer.
They are exploiting the trust placed in them.
Right. But if that same teller goes to a grocery store on the weekend and shoplifts an apple, they are just a regular thief. Their job title doesn't make the shoplifting worse.
The jurisprudence aligns with that distinction perfectly. There are several historical rulings that firmly establish that a public officer who does not leverage their official position might still be guilty of falsification, but only as a private person.
So no 1,000,000 peso fine for the shoplifted apple.
Right. The 1,000,000 peso fine and the prison mayor sentence are reserved strictly for the vault guards who rob the vault.
That makes total sense.
The law views the betrayal of designated trust as an aggravating factor that fundamentally damages the state's integrity. And this betrayal is broken down into 8 intricately defined acts of falsification under Article 171.
Okay, let's get into the mechanics of those acts. The first 3 acts read like, I don't know, the Hollywood definition of forgery.
The physical art of the fake.
Yes. Act number 1 is counterfeiting or imitating any handwriting, signature, or rubric. But the case law in our sources draws a really sharp, almost psychological line between counterfeiting and feigning.
Yes, the courts attempt to categorize the intent and the physical execution of the forger. So, counterfeiting requires an active attempt to imitate an existing original.
Okay.
And there must be a resemblance. The standard applied here is whether the imitation could pass in the rush of business.
In the rush of business, I want to pause on that because it's a brilliant standard.
It is very practical.
It really is. It acknowledges the reality of how human beings actually work. I mean, a clerk processing 100 forms an hour isn't inspecting every single signature with a magnifying glass.
Or running a forensic ink analysis, right?
Exactly. The law says the forgery just has to be good enough to fool someone moving at the normal speed of life.
That is the practical threshold. But a really fascinating legal problem arises when the person whose signature is being forged doesn't actually have a signature.
Wait, what do you mean?
What if the victim doesn't even know how to write?
Oh. Well, you can't imitate something that doesn't exist. There's no original to compare it to.
Exactly. And that scenario is what the law defines as feigning. I was reading about one specific ruling where the court examined a situation where an offender made it appear that a person who was entirely illiterate had actually signed a document.
Wow. That is bold.
The court ruled that this act is not counterfeiting because counterfeiting fundamentally requires an original to copy. Feigning is the creation of a signature that never existed in the first place.
That requires a completely different level of audacity.
Yeah.
You aren't just tracing a signature over a light box. You are, like, inventing a reality out of thin air.
You're fabricating a skill the victim doesn't even have.
Exactly. But let me ask you about the quality of the forgery. Say I forge a signature, but my imitation is so incredibly poor that a toddler could spot it.
Okay.
Let's say it looks absolutely nothing like the real signature. Is it still considered counterfeiting under this legal framework?
The jurisprudence actually addresses that exact scenario. The ruling dictates that there must be an attempt or intent to imitate, which is demonstrated by a comparison between the fake and the original.
So they put them side by side.
Yes. A sufficient resemblance is what justifies the legal conclusion that you actually intended to imitate it. If it is a completely absurd, disjointed scrawl that bears zero resemblance to the original, it fails the requisite elements of counterfeiting.
Because it could never pass in that rush of business we mentioned earlier.
Precisely.
But wait, even if they fail the test for counterfeiting because their forgery is terrible, the law doesn't just let them walk away, right? It seems like they would immediately fall into the trap of the second act under Article 171.
Oh, they absolutely would. Act 2 is defined as causing it to appear that persons have participated in an act or proceeding when they did not in fact so participate.
Ah, phantom participation.
Right. The rulings clarify that for this specific act, the document doesn't even need to be an authentic official paper. And the signature doesn't necessarily need to be a forged imitation of the victim's actual handwriting. The core crime is the fabrication of the event itself.
So the offender is generating a paper trail for a ghost.
Exactly. They are manufacturing a historical event that never actually occurred.
And then Act 3 takes the hijacking of reality even further. It penalizes attributing to persons who have participated in an act or preceding statements other than those in fact made by them.
This one is insidious.
It really is. So in this scenario, the person was actually in the room, the meeting actually happened, but you were literally putting words in their mouth on the official record.
The requisites for Act 3 demand that the person was genuinely present and that they made statements, but the offender, when drafting the document, attributed totally different statements to them.
It is the hijacking of the historical record.
And the danger here is profound because the foundation of the document is true.
Right. The meeting did happen.
Exactly. The meeting happened, which makes the lie hidden within it so much harder to detect.
Okay, so we've covered fake signatures and fake events. But what happens when the signature is real, the people are real, the meeting happened, but the story being told on the paper is just a flat-out lie? This brings us to what feels like the most complex and dangerous act of all. Act 4, making untruthful statements in a narration of facts.
This specific provision is a legal minefield. To secure a conviction under Act 4, the courts demand 4 incredibly strict requisites.
Okay, walk me through them.
First, the offender must make statements in a narration of facts. Second, they must have a legal obligation to disclose the truth of those facts.
That sounds tricky.
It is. Third, the facts must be absolutely false. And fourth, the perversion of truth must be made with the wrongful intent of injuring a third person.
Wait, always?
Well, no. The jurisprudence notes that wrongful intent isn't essential if the document in question is a public document.
Okay, I want to dissect that second requirement. A legal obligation to disclose the truth. Because for the average listener, common sense dictates that anytime you fill out a government form, you have a legal obligation to tell the truth.
You would think so.
Right. But the contradictions in the case law show that the courts view this through an incredibly narrow, rigid lens.
The lens is highly specific to the statute governing the document. Let me give you an example from the jurisprudence. The court ruled in one instance that there is an inherent, explicit legal obligation to disclose the truth when filling out a residence certificate.
Okay, that tracks.
Because the statute creating the certificate demands factual accuracy. If you lie on that specific piece of paper, you commit falsification.
But then you look at other situations. I mean, there's a ruling where the court found there was no legal obligation for the individual to reveal a previous criminal conviction on a personal data sheet.
Right.
Or look at the corporate formation ruling, where the court ruled there was no legal obligation to disclose foreign equity at the time of forming a public utility corporation. That completely upends how we normally think about official paperwork.
It is counterintuitive.
The law is literally saying, yes, you lied on this official government paper, but we never legally forced you to tell the truth in the first place, so it's not a crime under this specific article.
It highlights a critical boundary in jurisprudence. The penal code is not a moral code.
Right.
It is a strictly bounded set of rules. The courts analyzed the specific statutes governing personal data sheets and corporate formation at that time, and they found no explicit statutory command demanding that specific truth under penalty of perjury or falsification.
So if the law hasn't explicitly demanded the truth from you in a specific context,
then your lie, while perhaps highly unethical and certainly grounds for termination or civil action, does not constitute the criminal act of falsifying a narration of facts.
that distinction between a lie and a crime is so fascinating. Let me push that a bit further, actually. What if I genuinely believe what I am writing, but legally, I am totally wrong.
Okay, give me an example.
Let's say I am filling out a really complex tax document or a property deed, and I write down a legal conclusion about my property rights that is entirely incorrect. Have I made an untruthful statement in a narration of facts?
The courts actually addressed this exact boundary. The ruling established that a narration of facts is entirely distinct from a conclusion of law.
Oh, interesting.
In that specific case, the accused wrote a legal conclusion on a document that was, in reality, inexact and erroneous. However, the court recognized that a legal conclusion is an interpretation. It's a theory.
It's not a fact.
Right. It is not a pure narration of objective physical facts. Because her statement was a legal interpretation and wasn't entirely groundless or made in bad faith, it was not considered falsification.
Wow, that is a massive relief for anyone who has ever tried to navigate a labyrinth of government compliance forms.
The justice system recognizes that you cannot be sent to prison for simply having a flawed legal theory.
Oh, well, thank goodness for that. But let's shift gears from writing false facts to altering true ones.
Yeah.
Because the next sequence of acts under Article 171, Acts 5 through 8, deals with the physical manipulation of existing documents.
Yes.
It reads like a manual for a time traveler trying to rewrite history.
Act 5 penalizes the altering of true dates. But similar to the requirement of a legal obligation we just discussed, the law applies a strict filter of materiality here.
Meaning it has to actually matter.
Exactly. The date altered must be essential. If an offender changes a date on a document, but that specific date doesn't affect the veracity or the legal effect of the document itself, it does not constitute a crime.
So changing the date on an internal memo that just says happy birthday to the boss doesn't matter.
Correct. It has no legal weight.
But if the date is essential, it becomes a massive deal. The sources mention dates of birth, marriage, and death. And there is a really gripping example of the jurisprudence regarding the manipulation of time.
Yes, there's a case where the offender altered the dates on official receipts, and the underlying motive was to prevent the discovery of malversation.
Essentially covering up the embezzlement of public funds.
Right. By pushing the dates forward or backward, they were attempting to manipulate the timeline of an audit.
So they were using time as a weapon.
Exactly. They used time to hide a primary crime. The date on a receipt is the ultimate essential fact in an audit trail.
That brings us to Act 6, which is defined as making any alteration or intercalation in a genuine document which changes its meaning.
Intercalation is just a fancy word for insertion.
Right, squeezing a word or a number into a sentence. But this specific act introduces one of the most mind-bending legal rules in this entire stack of sources, the truth paradox.
Ah, yes. The truth paradox. This is derived from a landmark ruling where the court decided that if an alteration or insertion is made in a genuine document, but that physical alteration makes the document speak the truth, it is not falsification.
Wait, let me make sure I'm translating the mechanics of this correctly for you listening, because this is wild. Go for it. If you and I have a signed contract, and we verbally agreed the price of a car was 50,000 pesos, but the typist accidentally added a zero and wrote 500,000 pesos, we both sign it without looking.
Happens all the time.
Later, I notice the error. I take a red pen, cross out the 500, and write in the 50 to reflect our actual true agreement. I have technically altered a genuine signed legal document without your formal written authority.
You have.
Doesn't that encourage vigilantism with official records? I mean, if people could just legally cross out typos on official documents because they believe they're fixing the truth, doesn't that create absolute chaos?
That is the exact tension the courts had to weigh. But in the eyes of the law, the crime of falsification is fundamentally about the destruction of truth.
Yeah.
In the scenario you described, your physical alteration, while procedurally messy, actually repairs the truth. It forces the document to align with objective reality. Multiple rulings reinforce this logic. The correction of figures in a document to make it speak the truth is not falsification. The law prioritizes the abstract concept of truth over the physical sanctity of the original paper.
So the paper itself isn't sacred, the truth is.
Exactly. The courts determined that a document containing a typo is already a false reflection of reality. So correcting it cannot logically be the crime of falsification because you are not injuring the public faith, you are restoring it.
It is a stunning piece of legal logic. It acknowledges that paper makes mistakes,
Right.
and humans have the right to force the paper to reflect reality without being branded as felons.
It's surprisingly pragmatic.
It really is.
Yeah.
Now, up to this point, we have focused almost exclusively on the insider threat. public officials, people with badges, notaries with official state stamps. But we need to explore what happens when a regular citizen with no official power decides to forge a document.
Right, the private sphere.
Is the state just as unforgiving to someone who doesn't hold a public office?
This shifts our analysis to Article 172, which governs falsification by private individuals. And the state applies a very different calculus here. The penalty actually drops from prison mayor down to prison correctional. At ranges from 6 months and 1 day up to 6 years. Though I should note, the maximum fine remains at 1 million pesos.
Still a massive fine.
But the legal framework becomes significantly more complex because the law introduces a massive distinction based entirely on the type of paper the private individual is holding.
Okay.
The concept of damage becomes the dividing line.
The hierarchy of paper. Break down the mechanics of this divide for us. How does the law categorize these documents?
The jurisprudence divides documents into 4 distinct categories: public, official, commercial, and private.
Okay, 4 categories.
If a private individual falsifies a public, official, or commercial document, actual damage, or even the intent to cause damage, is not essential for a criminal conviction.
Right, really?
The crime is complete the absolute moment the document is forged.
Because the victim in that scenario isn't necessarily a specific person who lost money. The victim is the abstract concept of trust.
Precisely. The rulings articulate this beautifully. In the falsification of a public document, the principal thing punished is the violation of public faith and the destruction of the truth as therein solemnly proclaimed.
The state cannot allow the integrity of its registries or its commerce to be polluted, regardless of whether someone actually lost a peso.
Exactly. However, if a private individual falsifies a private document, the legal rule flips entirely.
Okay, how so?
To be guilty of falsifying a private document, actual damage to a third party, or the proven intent to cause such damage, is absolutely required.
Okay, we need to define these document categories clearly so the listener understands the stakes of what they might have in their filing cabinet right now.
Let's do it.
Let's look at the sources. Commercial documents, these are papers used to facilitate trade. The jurisprudence mentions airway bills. And quaidons. Let's explain what a quaidon is because it perfectly illustrates the mechanism of harm.
It's a great example.
A quaidon is a warehouse receipt, commonly used in the Philippines for commodities like sugar. It is a document of title. If I hold a quaidon for 10 tons of sugar, I essentially own that sugar without having to physically move it.
And that is exactly why forging it is so destructive. If you forge a quaidon, you are legally injecting phantom sugar into the commodities market.
Right. You're creating a claim on wealth that just does not exist.
Even if you never manage to sell that forged quaidon or hurt a specific buyer, the mere existence of that fake document damages the flow of commerce. It makes every legitimate buyer question the validity of real quaidons.
That is why the law doesn't require actual damage to convict you. The forgery itself is a direct attack on the economic ecosystem.
Official documents operate on a similar logic. They're issued by a public official in the exercise of their functions. For instance, the courts have explicitly categorized a driver's license as an official document.
Right. And public documents are those authorized by notaries or competent officials with solemnities required by law, like an official cash book or a burial permit. Forging any of these instantly pollutes the public record.
But then we reach the category of private documents, and there's a perfect illustration of this in the case law. A theater ticket.
A theater ticket.
Yes, a theater ticket is a deed or instrument executed by a private person without the intervention of a notary or a public official.
So if I sit in my house and forge an incredibly convincing theater ticket, but I just leave it sitting on my kitchen counter, I haven't committed the crime of falsification of a private document?
Because you haven't damaged anyone.
Right. The theater hasn't lost money.
Right.
But the moment I take that forged ticket, walk to the theater, and hand it to the usher to sneak into the show, depriving the theater of the revenue of a paying customer, then the damage is realized.
The crime is complete.
Wow.
The private sphere requires actual or intended harm to trigger the state's intervention. The state does not police private lies unless those lies cause material injury.
That makes a lot of sense.
But Article 172 introduces a procedural mechanism that is heavily debated in legal circles. It is a terrifying legal presumption that applies to anyone who handles these documents. It is often referred to as the presumption of authorship.
Oh, this part of the case law is intense. Walk us through the mechanics of this presumption.
In several landmark cases, the courts established a stringent rule. If an individual possesses a falsified document, and they use it, take advantage of it, or profit from it, the law legally presumes that they are the material author of the falsification.
Unless they can prove otherwise.
Yes, unless they can provide a satisfactory explanation to the contrary.
So if I hand over a forged driver's license to a police officer at a traffic stop, or I try to cash a forged check at a bank teller's window, I can't just play dumb.
No, you cannot.
I can't shrug and say, oh, I found it on the sidewalk, or a guy named Dave gave it to me. The law actively assumes I am the mastermind who manufactured the fake simply because I am the one holding it.
The rationale provided by the Supreme Court is rooted in raw pragmatism.
Pragmatism. Okay.
The court reasoned that the prosecution would almost never have the means to obtain direct eyewitness evidence of the actual forging process. I mean, forgery happens behind closed doors, clandestinely, in the dead of night.
Right. Nobody forges a document in the middle of a crowded plaza.
Exactly. If the state had to produce a video recording of the accused holding the pen to prove they committed the forgery, the conviction rate would be 0.
That makes sense.
Therefore, the burden of proof shifts. You are caught utilizing the forged document, so the law demands you explain the chain of custody.
That feels like a massive shift away from innocent until proven guilty.
It does feel that way, but there is a safety valve built into the jurisprudence, thankfully.
Okay, what is it?
The courts are aware of the danger of this presumption. A specific ruling provides the necessary boundary. The court ruled that this presumption of authorship is not applied if the evidence that the document is actually forged is extremely doubtful or weak. The presumption cannot override the constitutional right to the presumption of innocence if the fake isn't unequivocally proven to be a fake first. It prevents the state from weaponizing the presumption on flimsy grounds.
Still, it is a stark warning to anyone listening. Be incredibly careful about the provenance of the paper you present to the world.
Absolutely.
But this brings up a crucial question. What if the person holding the paper isn't trying to forge anything?
Okay.
What if they are completely innocent of any malicious intent, but they are just deeply, dangerously careless?
That transitions our analysis into the realm of accidental crimes. The law recognizes a concept known as falsification through reckless imprudence.
Reckless imprudence.
Yes. You do not need to be a criminal mastermind with malicious intent to fall afoul of these penal codes. You simply need to be a grossly negligent manager. The sources provide a spectacular narrative that illustrates this.
But let's humanize this case, because it is literally every manager's nightmare.
It really is.
Imagine you are the director of a busy hospital. You are working a 14-hour shift, dealing with medical emergencies, staffing shortages, and budget constraints. At the end of the day, your clerk hands you a towering stack of billing forms to authorize.
You're exhausted.
Exactly. You sign them all, assuming your staff did their jobs correctly. But it turns out, one of those forms wildly overstated the number of days a patient was hospitalized.
The numbers are false.
Right. The director didn't invent the fake numbers. He didn't even read them. He just blindly relied on his personnel. But the court convicted him of falsification through reckless imprudence.
The court's logic there is severe, but necessary. A signature from a hospital director on an official document is not just a casual autograph. It is a legal certification of truth.
Right.
By failing to verify the data he was authenticating, the director recklessly allowed a falsified public document to enter the ecosystem. His negligence was the direct conduit for the falsification.
But how does a bureaucracy even function if every manager has to personally recalculate every single math equation done by their subordinates? I mean, it would grind society to a halt.
The jurisprudence accounts for the realities of delegation, actually. We have to compare the hospital director in that case to a chief clerk in another famous ruling.
Okay, what happened with the clerk?
In that case, the chief clerk signed a certified copy of a birth certificate that contained false information. Like the hospital director, the clerk signed it relying entirely on a subordinate employee who prepared the document. However, the court acquitted the clerk.
Wait, why the different outcome for what seems like the exact same action?
The court held that the chief clerk was legally recognized to have the right to rely on his subordinate for that specific routine task.
Oh, because of the nature of his job.
Exactly. The nature of the clerk's office structurally required delegating the preparation of copies to subordinates. His reliance was standard operating procedure, not gross negligence.
But the hospital director was different.
The hospital director was certifying medical facts that demanded a higher standard of personal verification. The law measures the degree of duty attached to the specific signature.
So for the listener sitting at their desk right now, thinking about their workflow,
Yeah, listen up.
If you blindly sign off on expense reports or safety checks or compliance forms, you could literally be committing a crime if your negligence is deemed gross enough and you lack the recognized legal right to rely blindly on the drafter.
Your signature is a legal guarantee.
And sometimes these careless signatures or intentional forgeries are just the first physical step in a much larger, more destructive scheme.
Yes, this is what the Penal Code categorizes as complex crimes.
Right.
Falsification is rarely the end goal of a criminal enterprise. It is usually the mechanism, the crowbar used to break into the real vault. The sources detail a litany of examples where falsification is the necessary means to commit other, more lucrative crimes.
Let's look at one of the rulings involving estafa, which is the legal term for fraud. This was committed through the falsification of a public document. The offenders in this case counterfeited the signatures of officials on police stickers. These specific stickers functioned as official road or bridge passes for individuals holding certificates of public convenience.
The mechanics of the crime are entirely dependent on the paper. The offenders forged the public document and then sold those fake passes to unsuspecting drivers, thereby committing estafa.
So the falsification was just the necessary tool to execute the fraud.
We see the same mechanism applied to theft. There's a case where the offenders filled out an official purchase order with false entries.
Okay.
They then presented that falsified document to a warehouse, used it to obtain physical goods, loaded those goods onto a truck, and literally drove away. The fake paper was a key that unlocked the warehouse.
We even see the concept of reckless imprudence merge with these complex crimes, which creates this massive web of liability.
Oh, absolutely.
Like the ruling where the accused recklessly endorsed bank checks to identify the signatures to the supposed payees, despite the fact that he did not actually know the payees personally.
He was essentially vouching for strangers on a financial document.
Exactly. And because of his careless endorsement, the checks were cashed by imposters who stole the funds.
And the court found him guilty of estafa through falsification of a commercial document by reckless imprudence.
His failure to verify identity directly facilitated the theft of the money.
Every piece of paper is intimately connected to a physical action, a transfer of wealth, or the denial of a right.
We've explored the liability of public officials, the distinct rules for private citizens, and the terrifying reality of negligent managers.
It's a lot.
It is. But before we conclude, we have to examine the extreme edge cases in the jurisprudence. The law has carved out highly specific sections for niche violators where the stakes are just astronomical.
Yes.
I'm talking about legislators, priests, and telegraph operators.
Article 170 covers the falsification of legislative documents. This applies to any individual who, without proper authority, alters any bill, resolution, or ordinance enacted or pending approval by either House of the Legislature or any provincial or municipal council.
And the penalty here is staggering.
It includes the highest monetary fine we have seen in the entire text, up to 1,200,000 pesos, alongside prison correctional.
A 1,200,000 peso fine for changing a word on a document. Why is altering a draft of a bill treated with such overwhelming severity compared to, say, a standard government form?
Because the offender is tampering with the very DNA of the state.
Wow.
Let's look at the mechanics of legislation. A bill pending approval might regulate an entire industry, or define a criminal act, or allocate billions in public funds.
Right.
If a malicious actor can secretly alter a pending law, changing a shall to a shall not, inserting a misplaced comma that creates a massive tax loophole, or deleting a regulatory safeguard before the final vote, they are subverting the entire democratic process.
They are writing laws without being elected.
Exactly. The state demands that the meaning of the legislative document remains absolutely pristine because the ripple effects of a forged law could damage millions of citizens.
That makes total sense.
Yeah.
Then we move to the ecclesiastics, priests and ministers. Under Article 171, they are penalized with the exact same severity as public officers, but only if the falsification affects the civil status of persons.
The jurisdiction here is so fascinating. The state has no interest in policing the internal documents of a church.
Right.
If a minister alters a church newsletter or some internal doctrinal memo, the penal code is not engaged. But in many jurisdictions, the church acts as the de facto registrar of life events.
Like baptismal records often serving as official birth records.
Yes, or church weddings generating state-recognized marriage certificates. When a minister generates these specific documents, they are wielding state power. They are defining the civil reality of a citizen. Therefore, they are bound by the severe penalties of Article 171.
And finally, we have Article 173, the guardians of the wires, falsification of wireless, cable, telegraph, and telephone messages.
This specific law feels like a relic from the past, but the underlying logic is incredibly enduring.
It penalizes officers or employees of the government or private corporations who engage in sending or receiving these messages if they utter a fictitious message or falsify a genuine one. And there is a fantastic historical narrative in the jurisprudence about this.
Oh, the telegraph operator case. It's a perfect distillation of why this law exists.
Share the narrative.
So the narrative involves a telegraph operator. A citizen comes into the office, writes down an urgent message, and pays the operator by the word to transmit it.
Simple enough.
The operator takes the money, but intentionally reduces the number of words in the telegram he actually sends over the wire. He then pockets the monetary difference in the price charged to the customer.
It's brilliant in its absolute pettiness.
Yeah.
He is skimming pennies by deleting words.
Right. But legally, the implications are profound. He falsified a commercial communication. And the contrast in penalties defined by the sources here is what is truly striking.
Oh yeah, tell him about the contrast.
If a private person somehow manages to alter a telegram under a specific reference law, the maximum fine is 100 pesos.
100 pesos.
But if the telegraph operator alters the message, the penalties align with the severe sanctions of the penal code.
That massive disparity in the fine highlights the core philosophy of this entire jurisprudence. The severity of the crime is directly proportional to the level of trust society has placed in the offender's hands.
The telegraph operator, the notary, the hospital director, the public official, they control the transmission of the message. They hold the power to dictate reality for everyone else.
If the guardian of the medium is corrupt, the entire system is corrupt.
Exactly.
We have gone on an incredible journey through the depths of this penal code today. We started with the heavy, inescapable burden placed on public officials, the vault guards, and the strict, almost psychological legal definitions separating a counterfeit signature from the invention of a feigned phantom signature.
We dissected the rigorous requirements for narrating facts, learning that a lie is only a crime if the law explicitly demanded the truth in the first place.
Which was mind-blowing.
We examined the terrifying reality of reckless imprudence, where a simple failure to verify data can land a busy manager in court. And we explored the absolute requirement of public faith when it comes to commercial and official documents, where no actual damage is required to commit a crime, contrasted with private documents where material damage is everything.
And we looked at the paradoxical beauty of the law, where physically altering a legal document to fix a typo is not a crime because you're repairing reality rather than destroying it.
If there is one fundamental concept to take away from this analysis, it is that documents are the invisible glue holding civilization together.
Without a doubt.
These severe penalties, the million-peso fines, the years in prison, the terrifying presumptions of guilt, they exist because without an absolute rigid trust in the written word, commerce, justice, and governance completely collapse. The paper trail is the only structural defense we have against chaos.
Which leaves me with a final thought for you to mull over as we wrap up. We spent this entire time talking about the physical mechanics of truth.
Right.
The jurisprudence we explored is completely obsessed with physical interventions. Intercalations, handwritten signatures, physical registries, exact telegraph word counts. The law explicitly requires a physical original to compare a forgery against.
It's all based on paper.
But if the ultimate goal of the penal code is to protect public faith and the integrity of the record, how will these rigid, paper-based definitions survive in our impending reality where records are entirely digital?
That is the million-peso question.
What happens to the law when documents are generated instantaneously by AI, or when contracts live purely as code on decentralized blockchains, lacking any physical original signature to trace? If the crime of falsification fundamentally requires the physical destruction of a physical truth, what happens to the truth when the paper disappears entirely?
It forces us to ask if legal frameworks designed for ink and paper can adapt fast enough to protect public faith when the very medium of that faith is fundamentally changing.
We'll leave you to think on that. Thanks for joining us on this deep dive. Stay curious, watch what you sign, and we'll catch you next time.
Welcome to the debate. And Imagine standing in a courtroom, right? You're facing up to 12 years in a high-security prison, a total loss of your retirement pension,
And a lifetime ban from ever holding public office again.
Exactly, lifetime ban. But you didn't assault anyone. You didn't steal a single dime from the treasury. You didn't even defraud a citizen.
No, all you did was sign a piece of paper that, well, it contained a mathematical error made by your subordinate.
Right. And under the strict letter of the law, you might be branded a criminal forger for that.
It sounds like a dystopian novel, honestly. But, I mean, it is a very real lived reality within our legal system.
We spend so much time focusing on physical infrastructure, like bridges, highways, power grids,
Sure.
that we completely take for granted the invisible infrastructure holding society together. And that infrastructure is made entirely of paper.
Precisely. Official records, a birth certificate, a land title, a municipal ordinance, a commercial ledger. If an engineer alters a blueprint to hide a structural flaw, well, eventually the concrete fractures.
Right, you see the crack.
You see the crack. But if someone alters the official records of a state, the very concept of what is objectively true begins to collapse. That invisible infrastructure is, I would argue, far more fragile than concrete.
And when that intellectual collapse happens, the system loses its anchor to reality. Suddenly, the state cannot prove who owns a specific parcel of land, or, who is legally married to whom.
Or what tax laws have actually been passed by the legislature.
Exactly. The chaos is profound.
Which brings us to the central focus of our discussion today. We are analyzing the highly complex legal framework governing the falsification of documents, specifically parsing through the varying standards established in Articles 170 through 173 of the revised Penal Code.
Yeah, it is a massive, sprawling system. It categorizes and heavily penalizes the alteration of legislative, public, commercial, and private documents. I mean, it even reaches as far as covering the falsification of telegraphic messages.
It really covers all the bases.
It does. But the jurisprudence, the actual court decisions applying these articles, presents a fascinating and, frankly, deeply troubling philosophical divide.
So the central question we are debating is this. Should criminal liability for falsification focus primarily on protecting the intrinsic truth and integrity of the document itself, regardless of whether any actual harm occurred?
All right, or should the law fundamentally require an intent to cause damage and an intent to deceive in order to justify locking someone in a cage as a criminal forger?
Exactly. This debate emerges directly from our analysis of the Penal Code's differing standards and the accompanying jurisprudence.
Because we see this massive divergence in how the law treats public documents versus private documents. And, how the courts interpret the mental state required to commit these really severe crimes.
Well, I will be defending the law's strict standard today. I argue that punishing the violation of public faith fundamentally requires no proof of damage. Because frankly, the integrity of the system itself is the victim, and protecting that system justifies rigorous, unyielding standards.
And I will present the contrasting view. I'm going to argue that removing the requirement of malicious intent and relying heavily on legal presumptions of guilt to secure convictions creates a dangerously rigid system. It risks massive overcriminalization.
You think it goes too far?
I do, because it punishes the paper rather than the human being's actual moral culpability.
Okay, well, I think the best way to frame my position is to examine the core architecture of the Penal Code. The law correctly, and I'd say necessarily, prioritizes the preservation of public faith over individual measurable harm.
Mm-hmm.
When we read through the source material, specifically the ruling in the case of Damagus versus Milana, the court articulated this principle beautifully. When dealing with a public or official document, the principal thing being punished is the violation of public faith and destruction of truth.
Yeah, but notice the wording there.
It is the truth as solemnly proclaimed by the state. Therefore, under Article 172, it is entirely justified that actual damage, or even the intent to cause damage, is simply not an essential element when someone falsifies a public, official, or commercial document.
But that's incredibly harsh.
It's necessary. The law treats these documents as the foundational bedrock of civil society. If we require prosecutors to prove that a specific citizen was financially ruined every single time a corrupt notary forges a deed of sale, Well, we completely paralyze the state's ability to protect objective truth.
I just come at it from a distinctly different angle. While protecting public faith sounds incredibly noble in a legal textbook, the Penal Code's framework creates a highly mechanical and perilous system of justice when applied to real human beings.
How so?
Consider the stark contrast the law draws with private documents. In cases like U.S. versus Paradoso, the jurisprudence makes it crystal clear that to be convicted of falsifying a private document, there must be an independent act operating to damage a third person. You absolutely need actual intent to injure.
Right, for private documents.
But the moment a document is stamped public, the law aggressively strips away that requirement. Worse, it couples this strict liability approach with legal presumptions that basically assume your guilt.
I wouldn't say assume.
It effectively does. By abandoning the requirement for malicious intent, the jurisprudence strays from the foundational principle of all criminal law, namely, that criminality requires a guilty mind, or malice. We end up in this absurd scenario where the legal system acts like an overly sensitive immune system, attacking its own cells over harmless anomalies.
Well, I want to push back on that idea of the system attacking harmless anomalies, because I think your critique of the absence of malice misses the unique compounding nature of a public record.
I don't think it misses it at all, actually, and the text of the law backs up my concern. Look at paragraph 4 of Article 171. It penalizes making untruthful statements in a narration of facts. What does that mean in reality?
It means telling a lie on an official record.
It usually means a public officer filling out a standard bureaucratic form. If that officer makes an error, the courts, as seen in Sequian versus People, have established they can be punished simply if the facts they wrote down are absolutely false.
Yes, they have a duty to be accurate.
But there is zero requirement for the prosecution to prove a wrongful intent to injure a third person. The ruling in People versus Po Giocto confirmed this explicitly. Wrongful intent is immaterial when the document is public. Do you see the danger here?
You're saying it catches innocent mistakes.
This effectively criminalizes administrative errors. If a clerk fills out an intake form incorrectly and the information is factually untrue, the law doesn't care why they did it. It only cares that the document is wrong. How can we possibly justify imposing a severe prison sentence when the accused had absolutely no intent to deceive or harm anyone?
Because, the mechanism of harm for a public document is fundamentally different from a private dispute. Think about the underlying data architecture of society.
Okay.
Falsifying a private document is like two people having a contract dispute in a vacuum. But falsifying a public record, that isn't just an isolated lie. It is like injecting a corrupt line of code into a societal blockchain.
That's a dramatic comparison.
But it's accurate. Every single subsequent transaction that builds on that false blocked property sales, inheritance claims, tax assessments, marital rights, they're all invalidated. The corruption spreads automatically.
A corrupt line of code still implies a malicious hacker, though. My point is that paragraph 4 punishes the person who accidentally spills coffee on the keyboard and generates a typo.
But the jurisprudence recognizes that the state's regulatory framework cannot survive if we treat public documents casually. This exact tension played out in Dava versus People.
The driver's license case?
Yes, exactly. Dava versus People dealt with the falsification of a driver's license. The defense essentially argued, hey, no one was hurt, there was no damage caused, so there's no crime. And the court rejected that completely.
Because the system was offended.
Because the damage is immaterial. Society's reliance on the legitimacy of a state-issued license is what is actually damaged. If anyone can just print a fake driver's license without penalty simply because they haven't gotten into a car crash yet, well, the entire regulatory authority of the state collapses. The act of perverting the truth is the malice. You are knowingly introducing bad data into the public ledger.
That's a very clean, systemic view. But if you're listening to this and wondering how an honest clerk survives in such a draconian system, I mean, you aren't alone. Even the courts recognize this rigid, absolute textual interpretation goes too far in practice.
They apply it judiciously, yes.
They have to carve out emergency exits. In the case of People versus Unico, the court explicitly ruled that absence of malice or criminal intent is a defense, even in the falsification of a public document. This is a massive tell.
It's an exception.
It proves that the strict letter of the law saying intent doesn't matter is so dangerously absolute that judges have to step in and temper it to avoid catastrophic injustice. You cannot completely sever the act of writing something false from the mental intent of the writer without causing massive collateral damage to innocent administrators.
Hang on. I agree that Unico provides a necessary safety valve, but it doesn't dismantle the rule. It merely defines the extreme boundary of good faith.
But shows the rule is flawed.
No. The baseline standard must remain that the prosecution doesn't have to prove you intended to steal money or ruin a specific person's life. When you alter a public record, the perversion of truth is complete the moment the ink dries.
But if the law removes the need to prove malicious intent, it creates a massive evidentiary vacuum. If you don't care why someone altered a document, how do you even go about proving who did it without relying on motive?
Well, there are legal mechanisms for that.
And that brings me to what I consider the most egregious overreach in this entire framework, the presumption of authorship.
Ah, you're referring to the mechanism for proving liability under Article 172.
Exactly. Look at the Sandigambayan cases, specifically the doctrines upheld in People vs. Manasala and Picho vs. Sandigambayan. The established legal doctrine dictates that the possessor of a falsified document who uses it to their advantage is legally presumed to be the material author of the falsification. I'm sorry, but I find that deeply unconstitutional. You are entirely flipping the burden of proof.
Wait, let me make sure I'm following your critique here. Are you saying the law abandons the constitutional presumption of innocence just because it uses deductive reasoning to identify a forger?
It absolutely flips the burden. The Constitution guarantees that the state must prove your guilt. Yet here, the state says you submitted a forged land title to the registry, therefore you personally forged it. Now you must prove to us you didn't.
It's an inference based on logic.
We are forcing an accused citizen to prove a negative simply because they are the end user of a document that might have passed through a dozen different hands, brokers, or fixers before reaching them. It allows the state to substitute an assumption for actual rigorous investigative evidence.
I see why that feels jarring, but I think you're conflating an investigative shortcut with a necessary evidentiary bridge. It's about acknowledging the operational reality of how forgery actually works.
Which is?
The ruling in Kamibong versus People gives a brilliantly pragmatic explanation for this. The court notes that the prosecution would almost never have the means to obtain direct evidence to refute acts that are inherently contrived clandestinely. Forgers do not operate in public squares.
Obviously not.
They work in shadows, in private rooms, behind closed doors. If the law required an eyewitness to the actual pen stroke, 99% of forgeries would go completely unpunished. The presumption isn't laziness, it's a structural necessity, and crucially, it's not applied in a vacuum. It requires that the person possessed it, made use of it, took advantage of it, and profited from it.
But profiting from a document is an incredibly broad term. It could simply mean submitting a business permit you genuinely believed your fixer obtained legally.
You still benefited.
Yes, you are still possessing it, using it, and benefiting from it. Under this doctrine, you are now presumed to be the criminal mastermind who mocked up the fake seals in a basement.
That is why the jurisprudence provides a powerful, explicit safeguard. The state doesn't just get to wave a piece of paper and arrest you.
They do rely on it heavily, though.
But in Alonzo versus Intermediate Appellate Court, the ruling is very clear. This presumption is not applied against the constitutional presumption of innocence when the evidence of the forgery itself is extremely doubtful.
Well, I would hope not.
Right. The state still has to carry the heavy burden of conclusively, definitively proving the document is a fake first. They have to bring in the forensic experts, the original custodians, and prove the anomaly. Only when the forgery is undeniable and you are the individual uniquely benefiting from its use Does the law ask you to explain its origin?
Asking someone to explain its origin during an investigation is perfectly fine, but legally presuming they committed a felony, carrying a prison sentence, unless they can successfully point the finger at someone else, is inherently coercive.
It forces accountability.
It allows the prosecution to stop investigating the moment they find the guy holding the paper. It is an administrative convenience, masquerading as a legal principle.
I disagree that it's mere convenience, especially when you step back and look at how meticulously calibrated the penalties are across the code. This is not a blunt instrument swinging wildly. The framework scales the punishment directly with the breach of specialized trust.
I'm not sure I'd call it meticulously calibrated.
Let's ground this in the actual stakes. A public officer who takes advantage of their position to falsify a document under Article 171 faces prison mayor. That translates to between 6 and 12 years in an actual prison, absolute perpetual disqualification from holding office, and up to a 1 million peso fine.
Huge penalties.
Right. But if a private individual alters a legislative document under Article 170, say, a municipal ordinance pending before a provincial board, they face prison correccional. That tops out around 6 years and up to a 1.2 million peso fine.
Both of which are life-destroying consequences.
Yes, but the system intelligently recognizes that the betrayal of public trust by an official custodian is inherently more damaging to the state's integrity than the act of a private citizen. It's about authority.
It's still crushing.
It even extends to the ecclesiastical realm. An ecclesiastical minister who alters documents affecting the civil status of persons, like a baptismal record that functions as a birth record in certain jurisdictions, faces the exact same strict penalties as a public officer. The law maps the severity of the penalty to the societal reliance on the specific type of document and the authority of the person signing it.
You praise the calibration of the penalties, but you are completely ignoring how clumsily those catastrophic penalties are applied to simple negligence. This brings us back to the hook we started with, and it is my deepest critique of the entire system.
The reckless imprudence aspect.
Yes, the inclusion of reckless imprudence in this framework completely shatters the illusion that this is a finely tuned machine. Think about the hospital director in the case of People versus Bamis.
Okay, let's talk about Bamis.
Here is a medical professional, an executive, who was convicted of falsification. Why? Because he signed a bill that contained an overstated number of days of hospitalization. He didn't forge the numbers himself. He didn't have malicious intent to defraud the patient or the state.
He was careless.
He was a busy director who relied entirely on his administrative personnel's reports without double-checking their math.
He failed in his duty?
He was negligent. But applying the penalties of falsification to negligence, especially when there is no actual intent to deceive, conflates sheer incompetence with willful forgery. You are taking your beautifully scaled penalties, designed to punish corrupt officials betraying public trust, and using them to hammer an executive who just didn't audit his subordinates' paperwork.
I completely understand why the Bamatis case feels incredibly strict, but it serves a vital systemic purpose. We have to explain why the court views that signature so heavily.
Why a signature equals forgery?
Because public officers have an active, non-delegable duty to verify what they sign. As established in People versus Santiago Ui, there is a clear affirmative duty to make or prepare these documents accurately. When a hospital's director signs a public document, his signature is the ultimate guarantee of its truth to the public. If he signs it blindly, his recklessness is the exact mechanism that allows the false data to enter the public record.
But the system is entirely subjective about when it enforces that duty. You say the duty is non-delegable, but look at People versus Mendoza.
Ah, the civil registrar case.
Right. In that case, a chief clerk acting as a local civil registrar signed a certified copy of a birth certificate containing massive falsities. He didn't check the underlying documents either. But the court found him not guilty of falsification through reckless imprudence?
And this is exactly where the nuance of the jurisprudence shines.
Nuance or inconsistency?
Nuance. The court acquitted him because of a crucial legal distinction regarding structural context. In the Mendoza case, the chief clerk had a legally recognized right to rely on his subordinate employee based on the specific administrative protocols of that office.
He relied on a subordinate, just like the hospital director in Bahamas.
Yes, but this is the critical insight. The law doesn't just blindly punish every mistake. It evaluates the architecture of the bureaucracy. It distinguishes between a dereliction of a primary duty to verify, or your specific job is to be the final auditor, as seen with the hospital director, and a legally protected reliance on the chain of command, where your job is merely to process the documentation, as seen with the chief clerk.
That seems awfully semantic.
If your core function is to verify, your negligence acts as a forgery. If your function is to process, your negligence is just an error.
I have to say, that is a distinction without a difference for the human being facing a decade in prison. The fact that one clerk goes home to his family because a judge later decides his reliance was structurally protected, while a hospital director is convicted as a criminal for doing essentially the exact same thing, trusting his staff, proves my point entirely.
I don't think it's the exact same thing.
The line between being a criminal forger and committing an administrative oversight is far too thin and subjective in this framework. When you don't require an intent to damage and you allow felony convictions based on reckless imprudence, you turn the penal code into a human resources disciplinary manual, but with actual prison sentences. It's disproportionate to the moral failing.
It has to be more severe than a human resources manual because the systemic stakes for society are infinitely higher. A private company losing money due to an accounting error is a private tragedy, but the public registry containing false citizens, false marriages, false property lines, and fake legislative bills, that is an existential threat to the state.
I acknowledge the threat.
The strictness of the law, even encompassing reckless imprudence, forces the custodians of our public records to treat the ink they use as though it carries the weight of the law itself.
But we shouldn't sacrifice the foundational concept of mens rea, the guilty mind, just to keep the filing cabinets clean.
Well, as we wrap up this discussion, I want to re-emphasize my core position. The stringent standards for public, commercial, and legislative documents, where intent to damage isn't required, are an absolute necessity. By removing the requirement for actual intent to damage, the law acts as a proactive shield for the integrity of our societal records. The penalties, whether applied to deliberate malicious acts or to severe reckless imprudence, correctly reflect the massive magnitude of violating public faith. To return to our data analogy, the societal blockchain must be protected, whether the threat is a deliberate hacker or a careless custodian who leaves the server room unlocked.
And I maintain that while protecting public records is undeniably vital, the legal mechanics used here are fundamentally flawed and dangerous. By presuming guilt merely from the possession of a document, and by ignoring the foundational necessity of malicious intent, we have created a legal minefield.
A minefield for the negligent, perhaps.
The letter of the law here can and does punish those lacking true criminal culpability, branding negligent administrators as felons. It values the pristine nature of the paper over the actual mental state, the moral culpability, and the constitutional rights of the human being holding it.
I hear you, but I think where we do find strong points of convergence today is in acknowledging that the law successfully identifies a fundamental difference in impact between altering a private contract and altering a foundational public record.
Oh, I agree entirely on that point. A forged theater ticket and a forged birth certificate exist in completely different universes of societal harm. Our disagreement lies entirely in the legal mechanics of how we prove liability and assign guilt for those alterations.
Precisely. And for our listeners, this material really invites a much deeper exploration into a timeless legal struggle. How society balances the need for absolute, unvarnished truth in its public records against the individual rights and the presumption of innocence of those accused of altering them.
It is a delicate balance that the courts are clearly still trying to strike, case by case and human life by human life.
Indeed. So the next time you sign an official government form, look up a property deed, or simply hand over your driver's license, Remember the invisible infrastructure of paper supporting that entire interaction, and consider the immense, unyielding weight the law places on the truth of that single document. Thank you for listening to the debate.